Namaskar and welcome to the Indology podcast, where we go deep on all things related to Bharatiya philosophy, itihas and the eternal dharma. Here we uncover ideas of great Indic thought leaders through their writings, and where I read you excerpts from important Indic books. The book that I'm going to read you from today is a very, very important book, which is unfortunately not as well known. It was compiled by the great Sri Sitaram Goel and tells a rather fantastic story. The story of an event that has not been replicated anywhere else in the world. What if I told you that there was a time when some concerned citizens of India filed a petition to get the Quran banned? Because upon studying the Quran, which not many non-Muslims do and even many Muslims don't do, they realized that the book was not what they've been told it is. It dehumanized the non-believers to the point of demanding violent actions against them. And keeping all this in mind, these concerned citizens of society demanded that the Quran be banned. It might seem very difficult for us to believe right now in the secular times that we live in. And this was back in the 80s, by the way, when Nehruvian secularism was at its peak, where the Congress governments were in power all over the place. And to do such a thing in those times was indeed a rather brave act. And today, I'll tell you the story of that particular incident. Sri Sitaram Goel writes, Muslims in India have often sought shelter under sections 153A and 295A of the Indian Penal Code for preventing every public discussion of their creed in general and of their prophet in particular. Quite a few publications which examine critically the sayings and doings of the prophet or other idolized personalities of Islam have been proscribed under section 95 of the Criminal Procedure Code, as a result of pressure exerted by vociferous, very often violent Muslim protests. Little did they suspect that the same provisions of the law could be invoked for seeking a ban on their holy book, the Quran. The credit for this turning of tables goes to Chandmal Chopra of Calcutta. It was he who filed a writ petition in the Calcutta High Court on 29th of March 1985, stating that publication of the Quran attracts section 153A and 295A of the IPC because it incites violence, disturbs public tranquility, promotes, on ground of religion, feelings of enmity, hatred, and ill will between different religious communities, and insults other religions or religious beliefs of other communities in India. He also prayed for a rule nisi on the government of West Bengal to show cause as to why a writ of mandamus be not issued to it, directing it to declare each copy of Quran, whether in the original Arabic or in any of the other languages, as forfeited to the government, in terms of Section 95 of the CRPC. The case had caused considerable excitement among the believers, the Momins, and interest among the infidels. In April and May of 1985, the press in India and abroad gave many headlines to what was rightly regarded as an unprecedented event in the history of religion. It was the first time that a pagan had questioned the character of a document hailed as the very word of God by a people of the book. The roles now stood reversed. So far it had been the privilege of the peoples of the book to ban and burn the sacred literature of the pagans. The petition was disallowed by the High Court, but the issues raised by the petition remain pertinent. No law court can deny to infidels the right to know what treatment the Quran prescribes for them at the hands of the believers. Law has its limitations, particularly in a country where its main corpus continues to be what alien regimes, Islamic and British, had devised for their own imperialist purposes. Moreover, a law court is hardly the forum for framing final judgments on matter of grave moral and spiritual import. A free and forthright discussion of the Quran cannot and should not come to a stop, simply because the existing law is not competent to take cognizance of its contents. The surahs and ayats of the Quran, which Chandmal Chopra had cited in support of his plea, received scant or no attention at all. In the heat of the controversy whether a book regarded as sacred by a large number of people can be the subject of a lawsuit. Those who have not read the Calcutta Quran Petition, as it came to be known, cannot envisage the quantum and quality of evidence marshalled by Chopra. Our people are entitled to know exactly the issues that were involved. It is only a properly informed public opinion which can decide in the long run whether a book qualifies rationally, morally, and spiritually as a religious scripture or not. A brief history of the case will help in placing the petition in its proper perspective. Most people do not know why the petition was presented. They also do not know how the case was politicized from the very outset and what powerful pressures were brought into play even before the High Court had a chance to consider whether the petition could be admitted for adjudication. Before Chandmal Chopra came into the picture, Himanshu Kishore Chakrabarti, also of Calcutta, had written a letter on July the 20th, 1984, to the Secretary, Department of Home, Government of West Bengal, pointing out that the Quran contains matter which makes its publication an offence under sections 153A and 295A of the IPC. In 3 annexes to his letter, he has cited quite a few sayings of the Quran, 37 sayings which preach cruelty, incite violence and disturb public peace, 17 sayings which promote on ground of religion feelings of enmity, hatred and ill will between different religious communities in India, and 31 sayings which insult other religions as also the religious beliefs of other communities. He had requested that all copies of the Quran in the original Arabic as well as translations be forfeited forthwith to the government in terms of Section 95 of the CRPC. Citations made by Chakrabarti showed that he had made a painstaking study of the Quran. He had reason to do so. As a former resident of East Bengal, now Bangladesh, which became a province of Pakistan in August 1947, he had witnessed at the time of partition, as well as later on, a peculiar pattern in the behavior of the Muslim majority towards the Hindu minority. He had also known how the renowned religious leaders of East Bengal Muslims had approved of that behavior pattern as in keeping with the highest tenets of Islam. Ever since, he had been searching for the belief system which inspired this behavior pattern. He felt sure that he had found the primary source of that belief system when he studied the Quran. The Secretary of the West Bengal Home Department, however, did not even acknowledge Chakrabarti's letter. He therefore wrote a reminder on 14th of August 1984, enclosing a copy of his first letter along with the annexes. But 6 months passed and there was no response. It was during this interval that he met Chandmal Chopra, who had also been studying the Quran in order to understand why the Hindus in Bangladesh were being systematically uprooted from their ancestral homeland, even after India had made great sacrifices for securing freedom of Bangladesh. Chandmal Chopra is an adherent of the ancient tradition, which has all along stood for the 5 principal virtues prescribed by all schools of Sanatana Dharma: non-violence, truthfulness, non-stealing, chastity, and non-covetousness. It was a puzzle for him as to how adherents of another religion could persist in practices to the contrary, and that too with a good conscience. His question stood as if answered when he came to the Quran. He was in a position to confirm that the conclusions reached by Chakrabarti were correct. Chandmal Chopra now felt reinforced to do something about what he thought to be a matter of major public interest. So he wrote a letter on March the 16th, 1985 to the same secretary in the government of West Bengal, drawing the latter's attention to the contents of the Quran and referring to the demand made earlier by Chakrabarti. He requested that his letter be treated as notice demanding justice and made it clear that unless necessary steps were taken by the government of Bengal within 7 days from the receipt of his letter, he would take such steps as may be advised to us. Chopra's letter also remained unacknowledged. He therefore filed on March the 29th, 1985, his famous writ petition in the Calcutta High Court under Article 226 of the Indian Constitution. Seetal Singh, another public-spirited citizen, joined him as a co-petitioner. The grounds the petition gave for seeking action from the government of West Bengal were the same as provided earlier by Chakrabarti. But now, they were couched in appropriate legal language and presented according to the correct legal procedure. The writ petition came up before Mrs. Justice Padma Khastgir on April the 1st, 1985. She directed that the matter would appear in her list on April the 8th. There were, however, 2 postponements before the matter could appear on April the 12th. On that date, the learned judge gave directions for filing of affidavit in opposition by the 6th respondent, the state of West Bengal, by May the 3rd, 1985. An affidavit in reply by the petitioners by May the 17th, 1985. The matter then stood adjourned to May the 27th, 1985. The affidavit in reply was duly filed by the government of West Bengal, stating that as the Holy Quran is a divine book, no earthly power can sit upon judgment on it, no court of law has jurisdiction to adjudicate it, and that from the time of the British rule and since independence, in spite of the Indian Penal Code being in existence, there had never been such an application in any court in India. But for reasons unknown, Justice Kastgir released the matter from her list on May the 2nd. On May the 7th, the Advocate General of West Bengal requested the Chief Justice of the Calcutta High Court to assign the matter to another bench. Finally, on May the 10th, the Chief Justice chose Mr. Justice Bimal Chandra Basak for hearing the writ petition. Meanwhile, all hell had broken loose. The Telegraph of Calcutta, dated May the 9th, carried a UNI report, datelined New Delhi, May the 8th. The report said, the Union government has decided to intervene in the writ petition in the Calcutta High Court, praying for a ban on the Quran. According to an official release, the Law Minister Ashok Sen is proceeding to Calcutta immediately for giving the necessary instructions. The government has decided to seek the outright dismissal of the petition, the release added. It is also understood that the Attorney General of the Government of India is being briefed to appear in the case. A staff reporter of the Telegraph added, Justice Kastgir has asked the state government and the union government to show cause as to why the Quran should not be banned. The order created considerable resentment at the Bar Association in Calcutta, where Muslim lawyers had called an extraordinary meeting and moved a motion for condemning Justice Kastgir for having admitted the case. The motion was, however, defeated as the lawyers moving the motion could not muster enough votes. The Telegraph, dated May the 10th, reported that the same sort of pressure was being mounted by the government of West Bengal. It wrote, the Chief Minister, Mr. Jyoti Basu, today, May the 9th, described the writ petition filed in the Calcutta High Court challenging certain portions of the Quran a despicable act. Mr. Basu, who was replying to the Forward Bloc MLA, Mr. Anil Mukherjee, in the State Assembly, also felt that the court should have dismissed the petition outright as the subject matter pertains to religion. According to him, the union government has already contacted the state authorities who had sought the former's help in resolving the issue. I have also told the Advocate General to talk to the Chief Justice of Calcutta High Court in this regard, Mr. Basu added. It did not occur to Jyoti Basu that the matter being sub judice, he was committing contempt of court, nor did the court reprimand him for this breach of law. The matter was also raised in the Lok Sabha at New Delhi on May the 10th by two MPs, one belonging to the Congress I and the other to the CPI-M. According to the Statesman, dated May the 11th, the Speaker, Mr. Balram Jakhar, agreed with them that this was a serious matter. There was, he noted, enough trouble in the country, and there was no need to add anything which would stir up another conflagration. What bothered Balram Jakhar was the fear of trouble and not the right or wrong involved in the case. In fact, he was inviting Muslim mobs to take to the streets and create trouble. In his reply to the MPs, the Minister of State for Law, H.R. Bhardwaj, said, when the writ petition had come to the government's notice, the government had immediately considered measures to counter it, and that the government was deputing the Attorney General to Calcutta to seek dismissal of the writ petition. The government and politicians of Pakistan, however, were not impressed by the government of India's effort to protect the Quran. The Telegraph, dated May the 14th, carried a PTI report datelined Islamabad, May the 13th. It said, Pakistan's Minister of State for Religious and Minority Affairs, Mr. Maqbool Ahmad Khan, said today that the petition against the Quran moved in the Calcutta High Court was the worst example of religious intolerance. The Pakistan President, Zia-ul Haq, was quoted by an Urdu daily as saying that the facts of the case were being ascertained. Mr. Khan alleged that religion and life and property of minorities were unsafe in India and urged the Indian government to follow the example of Pakistan in ensuring freedom of religion. He said, if the Quran had been banned in the name of secularism, the religious books of Hindus should also be banned. Maulana Kausar Niazi, a pro-Zia politician, asked the Organization of Islamic Conference chairman, Mr. Sharifuddin Pirzada, to draw the attention of the Muslim world to react against this heinous act. He asked the government to make an official complaint to India and appealed to the Pakistani religious leaders to observe Friday as a protest day. Thus, the theocratic state of Pakistan made it an occasion for delivering lectures to Indians on the subject of religious freedom and the right of minorities. Nobody who was anybody in India at that time is known to have reacted to this assault from an Islamic state which had driven out most of its Hindu minority and was treating the rest as non-citizens. The governments of India and West Bengal had panicked because of their presumption that the writ petition had been admitted by Justice Padma Khastagir, but this was by no means certain. The Telegraph of May the 10th carried a report of the controversy which was raging in Calcutta around this point. It said, "There is a serious difference of opinion between Chief Justice Satish Chandra and Justice Padma Khastagir on the one hand, and the Advocate General Mr. Snehangshu Acharya and a large number of lawyers on the other, on whether Justice Khastagir had admitted a writ petition demanding the banning of the Quran. Justice Chandra and Khastagir maintain that the petition moved by Chandmal Chopra and Seetal Singh was not admitted in the court. However, the Advocate General and a large number of lawyers are convinced that the petition was admitted by Justice Khastagir. The significant fact is that the controversy has acquired a serious dimension only because Justice Khastagir entertained this mischievous petition instead of dismissing it outright. Justice Khastagir told the Telegraph that she issued directions on the petition as she would not turn down any petitioner. Meanwhile, the Registrar of the High Court has informed the Telegraph that he has been directed to state that the petition under Article 226 has not been admitted by Justice Khastagir. The accomplices of Islamic imperialism in India, communists, socialists, Nehruvian secularists, Gandhians, were throwing all judicial proprieties and procedures to the winds in defense of Islam, which they viewed as the most effective weapon against their common enemy, Hindu society and culture. Spokesmen for the state and the union governments could not or did not want to see the contradiction involved in their stand. If, as they affirmed, the petition had been admitted, the matter was sub judice and their comments on it constituted contempt of court. But if it had not been admitted, they should have waited for Justice Khastagir's ruling regarding its admissibility. Obviously, the panic created by mounting Muslim protests had paralyzed all rational faculties in certain quarters. According to the Telegraph dated May the 10th, the Union Law Minister, Mr. Ashok Sen, informed the Advocate General that the Union government would make itself a party to the case, as it would affect the Muslim community all over the country, and that the case would have international ramifications. Political considerations, thus, came to override legal proprieties. What was still more reprehensible, the government of West Bengal set in motion its intelligence branch for digging up some information which could be used for a smear campaign against the petitioners. The Telegraph dated May the 10th reported, according to an intelligence report, Chandmal Chopra and Seetal Singh are not permanent residents of the addresses given by them. Chandmal Chopra, who said he resided in 25 Bartola Street, does not stay there. According to the report, Chandmal, aged 55, has a room in his name at the above-mentioned premises. The 50-year-old Seetal Singh is an ex-army man and resident of Hyderabad. He occasionally comes to the city and stays at 1 Sadruddin Street in North Calcutta, which is actually an Arya Samaj Mandir. Both of them did not have any police records, nor were their names on any special branch files. Obviously, police files had been rummaged in order to locate something which could compromise the character of Chandmal Chopra and Seetal Singh. No one from India's public life stood up to ask the simple question whether checking the police record of someone was legal or legitimate just because that person has filed a writ petition in a high court. The panic on the part of the state and union governments could not but produce some more unsavory results. Muslim mobs in India and elsewhere had been incited by all those who mattered in India, Pakistan and Bangladesh. They started taking to the streets and turning violent. The Statesman, dated May the 13th, published the following news, datelined Dhaka, May the 12th. At least 12 people were killed and 100 wounded when Bangladesh police fired on a demonstration yesterday in the border town of Chepal Nawabganj, 320 kilometers from here. Some 1,000 demonstrators belonging to the fundamentalist Jamaat-e-Islami were protesting against a case filed by 2 Indian civilians in Calcutta High Court, calling for a ban on the Quran in India. The town chief administrators said today that the police opened fire in self-defense when the demonstrators went on a rampage, throwing missiles and setting ablaze government property. Yesterday's incident followed a demonstration by at least 20,000 Jamaat-e-Islami supporters in the capital on Friday, May the 10th. The demonstrators in Dhaka, according to other reports, were trying to storm the office of India's High Commission when they were stopped by the police. The Statesman, dated May the 14th, carried a report dated May 13th from Ranchi in Bihar. It said, "Agitated over the writ petition concerning the Quran, Muslims here marched in protest for the second day. The marchers carried banners and black flags and shouted anti-government slogans. Yesterday, some processionists threw stones at a few shops on the main road, while asking the shopkeepers to pull their shutters down. Following yesterday's incidents, most of the shopkeepers today preferred to keep their establishments closed when the procession was taken out." On the same day, widespread violence was staged by Muslim mobs in Srinagar in the Kashmir Valley, which was to become a center of widespread Islamic terrorism 4 years later when VP Singh, an unashamed champion of Islamic imperialism, became India's Prime Minister. The Telegraph, dated May the 14th, reported, "The police fired to disperse a mob which ransacked the CPI headquarters in Srinagar today in protest against the petition seeking to ban the Quran. An attempt was made to set fire to a bridge. There was violence in other parts of the city, and demonstrators carrying black and green flags stoned the police. Shops and cinema halls were closed, and as a precaution, the authorities shut down all educational establishments. Slogans were raised against the West Bengal government." There could be no greater irony that the Communist Party of India, a consistent defender of all Islamic causes, had been bracketed with Hindu communalists by Muslim mobs. But mobs are mobs, and the responsibility for what they do rests on those who mobilize them ever so often. It was in the midst of this mob fury that the Times of India published 3 articles by Dr. Rafiq Zakaria in praise of the Quran. It was one of the many efforts being made by concerned authorities to mollify the Muslims. According to knowledgeable circles, the articles were a command performance. The developments that took place in the Calcutta High Court were no less dramatic. As stated earlier, Justice Kastgir had directed Chandmal Chopra to file his affidavit in reply by May the 17th. He was busy preparing for it when he received a message on the midnight of May the 12th that the matter would appear to be mentioned on May 13th before Justice Basak. Next day, when Chopra appeared in the court, Justice Basak recalled the earlier court directions regarding filing of affidavits and directed him to move the writ application afresh as a court application. Chopra had no alternative and had to do what he was told to do by an august authority. On the other hand, the Attorney General of India and the Advocate General of West Bengal had come to the court fully prepared, as was obvious from the fat volumes they had brought with them. Chopra requested for an adjournment on the ground that he had received notice only for to be mentioned, but this request was rejected. The Advocate General of West Bengal and the Attorney General of Government of India were directed to proceed with their arguments against the writ petition, which they did with considerable confidence. Ill-prepared as he was, Chopra tried his best to counter the arguments. Justice Basak then dismissed the writ petition and reserved his judgment for a later date. The judgment, which Justice Basak delivered on May the 17th, is a lengthy document. It quotes copiously from criminal and constitutional case law. It also contains some passage about the profundities of Islam and India's philosophy of secularism. In between, there are some observations about the eternal, the unknowable, the transcendental, and so on. There was, however, one point in the judgment which had a sequel even after the Calcutta High Court considered the matter as closed. Justice Basak had criticized Justice Padma Kastgir for having admitted the writ petition. He had pronounced, "The application was entertained and admitted without going into the question of prima facie case and the jurisdiction and power of the court to entertain this petition. In spite of the same, directions were given for filing of affidavits. This by itself amounts to holding that there is a prima facie case, though this question was not gone into. The court should be circumspect in such kind of matters and be very cautious about the same. Otherwise, though it might attract cheap publicity, but may cause untold misery and disruption of religious harmony. The petition should have been rejected forthwith, and enlightenment as unworthy of its consideration as soon as it was moved. Some Muslim leaders pounced on this point to demand action against Justice Padma Kastagir. A notable example was G.M. Shah, the Chief Minister of Jammu and Kashmir. He had returned from abroad on May the 20th after a month's stay in the USA. On the same day, he addressed a mass rally at Iqbal Park in Srinagar. According to a PTI report reproduced by Navbharat Times, New Delhi, dated May the 22nd, Shah said that action should be taken against the judge who permitted the petition to be filed. The mass rally itself was the climax of continued violence in the Kashmir Valley, even after the writ petition had been dismissed on May the 13th. Leaders of the Muslim community in Kashmir had widened their protest against the writ petition for voicing some permanent Muslim grievances. The Statesman, dated May the 18th, had carried a news datelined Srinagar, May the 17th. It said, "One person was killed and at least 3 persons were seriously injured when the police fired and exploded tear gas shells to disperse a stone-throwing mob at Fateh Kadal in Srinagar today," according to police sources. Srinagar and other parts of the Kashmir Valley today observed a bandh in response to a one-day hartal called by Mirwaiz Maulvi Farooq, chairman of the Awami Action Committee, and other leaders. Shops and commercial establishments were closed in the city and other towns of the valley, and vehicular traffic came to a standstill. Banks and government offices were open, but schools and colleges were closed for the day. The hartal is being observed in protest against the conspiracies against the Quran, interference in Muslim personal law, communal rights, and the increasing cult of violence in the country. Another sequel to Justice Basak's judgment may be mentioned briefly. Chandmal Chopra filed a review petition on June the 18th, 1985, stating that the premises on which the judgment was based were not sound. He gave 8 grounds on which the judgment could be reviewed. In violation of the normal judicial procedure, the review petition also came up before Justice Basak on June the 21st. He dismissed it the same day for purely technical reasons without going into the grounds. The only concession he made was that some of the grounds may or may not be grounds for appeal. And this, ladies and gentlemen, was the excerpt from the Calcutta Quran Petition. I would encourage all of you to pick up this book and read it, especially if you have interest in Islamic ideology. I hope you liked this episode of the Indology podcast. If you did, then please give me a 5-star rating on Spotify, Apple, or whichever platform you're listening to this on. And if you are listening to this on YouTube, then please like this video and subscribe to my channel. Press that bell icon. You should also follow me on the social medias. I am everywhere, all over the place. The name is the same, Indologia, Indologia. Until the next time I see you, Jai Hind, Vande Mataram.